All right, I think we're ready to go. We have a mixed calendar this afternoon of some plea and arraignment, some final plea, etc. Position one is Brian Hall. Good afternoon, Mr. Hall. I'm Judge McBurney. Nice to meet you. This was transferred from non-complex, but we're going to treat it as a fresh start, even though it's an old case. What are we doing with Mr. Hall?
Judge, I am in the process of waiving formal arraignment and a plea of not guilty. It looks like he updated the address in Odyssey on his own accord back in October.
Great.
And I've gotten good contact for him and I've given him mine. And so I did learn today that he lives in Chattanooga, so I'll be hoping to
have virtual appearances.
Yes.
Apartment B6. Thumbs up. Okay. Ms. Nix, will this be your case? And good afternoon. Okay. So we'll waive and do a scheduling order. Let me see if there's anything about your bond that we ought to talk about, because you may well have been on bond for a long time, given the age of this case. So you got a bond back 3 years ago in a couple of weeks. And how's your license? Is good? As in, like, if you showed Deputy Gordon your license right now and he ran it, it would be a valid drive. You don't need to, but it's a valid driver's license. Is it a Tennessee license or a Georgia? Tennessee. Okay. That's the main thing, is that you're not supposed to drive unless you got a valid license, but you got that fixed. Okay. All right. Ms. Wood, anything else on behalf of Mr. Hall?
No, thank you.
Mr. Hall, the prosecutor, who's Ms. Nix, is going to get discovery to your lawyer. She's going to want to review that with you. You can do it virtually. You're not going to need to come back here to do that. Mostly stuff she can send you. And then we'll figure out what's happening next with your case. At some point, it'll either be time for you to work it out or to have a trial. If it's a trial, you need to be back here. If it's a plea, and depending on how it's structured, you might be able to appear virtually, meaning on Zoom. But I'll let Ms. Wood talk to you about that. You have any questions about anything? Do you need Mr. Hall to stick around?
No, Judge, thank you.
Ms. Nix, anything else from the state?
Yes, sir.
All right, Mr. Hall, thank you for being here. Position two is Christian Rakestraw.
Judge, this is mine. I think we're gonna be able to resolve this today, so if we can come back to this one.
Got it. Okay. Mr. Muse, is Mr. McClendon, I think, waived arraignment on all his, but one case Ms. Rios is keeping, or not, keeping may not be the right word, but I think one of Mr. Muse's cases, Ms. Rios is on, in fact, it's position 4. It's the re-indictment of a case.
And I think that even though it's a re-indictment, when before it was re-indicted, it had been to arraignment, so I believe for this set of facts, it's already been arraigned.
Okay, but importantly, Mr. McClendon waived arraignment on position 3. So we'll do a scheduling order. You think position 4, because you think there was a waiver in the earlier case? Yes, Ms. Nelson is saying that's all been handled. Okay. Waive and schedule. And Mr. Muse, who has been an extremely public, productive member of the community, has a third case. That's also with Mr. McClendon, but he's waived in that as well. I don't know that there's anyone who can talk to Mr. Muse since Mr. McClendon's not here. So if he's up, we're not going to need to see Mr. Muse. All right. Co-defendant to Mr. Muse is Joseph Daniels. Mr. Daniels, you're here, and your lawyer is on the screen. I'm going to get him big on the screen there, spotlight for everyone, and then we'll add gallery. So we've got that. Good afternoon, Mr. Lim. How are you?
Good, Judge. How are you?
I'm all right. Today is plea and arraignment day for Mr. Daniels. You may have already filed it, but are you planning on waiving arraignment, or does Mr. Daniels want to be formally arraigned?
It's been waived since October the 17th.
Okay. Let me check one thing in this case. Ms. Nix, any issues in getting discovery to Mr. Lim? If it hasn't already happened? Okay. Let's see. Yep. Waiver of arraignment. So, Mr. Lim, we've had a couple cases together. The way this will work is that I'll get a scheduling order issued. It will give the state a deadline to get you discovery, and your motions deadline is not until after that. So you'll have a chance to confirm that you've got what you think is all the discovery. If there are any motions to suppress or anything like that, you'll have a deadline to file those, and we will move the case along. Deputy Gordon, Mr. Daniels has a W on his entry. Have you checked that? No, okay. Let me see what else we've got. Mr. Daniels, the address I've got for you is on Middleton Road. Is that still a good address? Okay. All right. Mr. Lim, anything else on behalf of your client?
No, Your Honor, but since Mr. Daniels is out, I would like to get his number, if Your Honor would let me.
Sure. I can have him write that down, and then I can put it in the chat just to you so we don't circulate it. Do you mind when Deputy Gordon comes back? Mr. Daniels, I'm going to get you to just write the best phone number for you, and then I'll get that to your lawyer so he has a way to reach you, okay? I got a pad here if you won't want to tear up your calendar. All right. All right, so if you'll hold on, Mr. Lim, until I get you that information. We've got another co-defendant, a Kevion Beaufort. Buford. All right, Mr. Buford, good afternoon. How are you doing? And your lawyer is Mr. Tolles. Is he on our call? I don't see him. When did you last talk to Mr. Tolles? Okay. Tell me what you and Mr. Tolles, I'm going to ask this the right way. I don't want to know about private conversations you have with Mr. Tolles. He's listed as your lawyer. Did you pay him some money?
Yeah, last time I talked to him, though, when he gave me my court, that's it.
Okay. What I can do is have you talk with Ms. Wood briefly to see if you qualify, because if you were able to pay Mr. Tolles, it may be that you don't qualify for a public defender. We also need to make sure there's not a conflict here. There are a bunch of defendants on this case, but at a minimum, we'll figure out if you qualify, and if you do, it may not be Ms. Wood who represents you, but we will get someone appointed to represent you so we can keep the case moving forward. Let me call up your case and see what we get here. You are Buford. There it is. So Mr. Tolles filed an entry in August. I can't really replace him unless he files a withdrawal. Have you all talked about that at all? Or your point is, I call this guy and he won't call me back?
I'm not sure I talked to him.
You will talk to him about it? Okay. Why don't we do that? I'm going to have you stay because I would like Ms. Nelson, who works with me, to reach out to Mr. Tolles. That maybe he can pop on the Zoom and we can sort all this out. And he may say, no, I'm in, I'm representing him. Or he may say, no, it didn't work out. Okay. Let me check something here. All right, so you'll sit tight. We'll circle back to see about Mr. Tolles. Another co-defendant, Jarquavis White. Mr. White, good afternoon. That's you?
So, well, we actually conflicted out on October the 8th. It looks like Ms. Cabrera entered into the case on October 22nd.
To represent Mr. White?
Yes.
Okay. And you think she actually, so I got the contrary information? Tell me what, well, here's what, I can write the numbers, I'll trade you that, because I think I need that. But if you lean over those two from your office, see that right there?
Yes. I'm going to send him a check.
Okay, or you could call her, however you want to do that. That's Ms., I think that's a Ms. Dill is showing that.
Okay.
All right. I can't change that either. All right. Oof. All right, Mr. Lim, I'm gonna send you the number via chat, and then you should be good to go. Make sure it goes just to you. You get it?
Yes,
You're
Your
on
Honor.
mute. Yes, okay, great. All right, thank you.
May I be excused?
You may want to hold on for 1 sec, and
Okay.
then we'll figure it out.
Okay.
Thanks. I need to look up Mr. White. So she is listed as your lawyer. So we're going to reach out to her, Mr. White. Ms. Cabrera has been appointed to represent you, and hopefully she can drop in the same way we're hoping Mr. Tolles can drop in, and let us know what she wants to do, or at minimum, you two can exchange contact information and then have a private conversation, okay? So sit tight. And the final co-defendant in this case is Mr. Key, who is in custody, and Mr. Scheib doesn't represent him anymore. So do we need to get, I know there were family members for Mr. Key here. Is anyone here for Mr. Key? A lot of people are here for Mr. Key. So Mr. Scheib has withdrawn. Were you all planning on hiring a lawyer for Mr. Key, or does he need a lawyer up? He has a new lawyer. And who would that be? Ms. Bumpus. All right. Any idea where she is?
I just step out and call her and see.
That'd be great if you would, please. And she can parachute in through Zoom if she needs to. All right, so Cabrera, Bumpus, and Tolles we're all waiting on. Ms. Bumpus said she would be 30 minutes late, so she's not late yet. She hopes to be here. All right, we'll circle back to that case. Isaac Estrada. Nope. But let me see. There's a lawyer involved who maybe filed something already. Oh, I have stuff written down here. Entry completed, but no waiver filed. So they need to be here. Okay. Ms. Nix, have you heard anything from Ms. Alejos, the lawyer?
Off the top of my notes say that it was waived via paper, so it's,
Oh, okay. That's
their notes are probably better than mine.
yeah, actually, the entry of appearance says waiver of arraignment on it in this entry here, so I may have bad notes. Let's look. Yep, not guilty. So, we will count that as a waiver and scheduling order. And will this be your case?
Yeah.
All right, so that's Estrada. Martavius Gay.
Judge, this is a gentleman who I believe Mr. Bernard has been granted.
One shade, one.
Yeah.
Judge call your name, make you stand and acknowledge.
Okay, he's with Mr. Key, I think. Ms. Bumpus, did she give you an update?
Said she just left her phone and her purse down at I guess the entrance, so I'm about to go down there and see if she is. Somebody answered the phone, I guess the sheriff, I don't know.
Okay, but that seems like she's in the building if her phone's in the building.
Yeah, that's what it said.
Sounds good, okay.
I just spoke with her like right before I came in here, so I don't understand what she did. So
Okay.
I'm gonna slide down there and see what she.
Yeah, you may want to check courtroom 1C.
Want to see?
Sometimes she's there. All right. Yes, Mr. Gay, we let Mr. Bernard off, but we need Mr. Gay.
Yes, Judge, so I did reach out to a number that I found in Odyssey and left a message, but otherwise I haven't.
Okay. Well, if he doesn't arrive this afternoon, bench warrant, Ms. Nix?
Yes,
Okay. Terrell Stokes. Hey, Mr. Stokes.
He is Ms. Rios's client. I think she's already filed a waiver.
Let's see, Stokes.
Good.
If so, that was recent. Let me look it up. Let's see. Whoops. Mr. Stokes, we do waiver of arraignment, just filed. All right. Do we feel like you've got good contact for Mr. Stokes or should?
She's spoken with him, so.
Got it. You've talked with Ms. Rios before? Fantastic. Well, she should have told you didn't need to come, but that's all right. It's good you're here. Ms. Rios has waived arraignment, which just means she's entered a plea of not guilty for you. Prosecutor's going to get discovery to her. She will get it to you. You all will talk about it and figure out what you're doing next. Let me check two things with you while we got you here. I've got an address. I have two different addresses, one in Riverdale and one in Lithonia.
I just gave her my recent.
Oh, look at this. And she filed a change of address. It just hasn't made it into the system yet. Clarkson, you get around. All right. So, and no apartment number, just the 4 digits. Oh, apartment F, that's not in the change of address. So I'll let her know that it should be those digits plus apartment F. Okay. Apartment F. All right. One last thing. Let me see what your bond says. Make sure there's nothing funky. Are you wearing an ankle monitor? You have had that ankle monitor now for 1.5 years. Okay. Ms. Wood, would you make a note to let Ms. Rios know to file a motion for bond modification and to consult with Ms. Nix? It may be that the ankle monitor ought to stay on, but that's about 12 months longer than our default ought to be. You're staying away from Andre Garrett and Andre Garrett Jr.? Okay, and Ms. Green? Okay, good. Ms. Rios will talk to you about the ankle monitor. Right now, it says you are supposed to be on a 24-hour curfew. Did you ever get that modified, or are you still on that? No, which you are not honoring the 24-hour curfew, or?
I didn't get it modified.
Okay, so, oh, but you can go to work as long as you provide a work schedule, that kind of thing. Okay, well, that would be another thing that we ought to reevaluate now that it has been 18 months and you showed up in court. It's time to think about whether an ankle monitor is still a necessity. Is it county funded? You're not having to pay for it, correct?
I think I did have to pay for it through my bond.
Okay, you shouldn't, because it says here paid for by county. Anyway, we will, Ms. Rios will bring that up and we'll figure it out, okay? Any questions about anything? All right, Ms. Nix, anything in the Stokes case? All right, Rios.
What's the apartment number that you?
F as in Frank.
Thank you.
You're gonna let her know that?
Yes.
Great, so ankle monitor and apartment F. That's it, you're free to go. Appreciate it. Ezekiel Stevens,
He's in custody, Judge.
he's in custody, okay? And there's a private attorney listed?
They withdrew, I believe, yesterday. This is an SB 440 case. I've spoken to Ms. Clark with our office. She had a conflict, so couldn't be here today. I've also spoken to Mr. Stevens. I believe Ms. Clark will be filing a waiver, and also a bond motion soon.
Okay, so Angela Clark will have the case, can't be here today, but it is a PD case. Do you want Mr. Stevens to come to the door? You'll talk to him? How do you want to
I've
manage?
spoken to him. If we could bring him to the door.
Sure.
So, he does have his mother's here present.
Okay, hey, Mom. Okay, before we do that, do you have an update?
Yes.
Okay, just tell me how you want, you got it? Okay, all right. If we could bring Mr. Stevens to the door, please.
Before doing that, he is in custody because of a warrant that Ms. Singleton had issued based on violation of his bond.
Right, this is why I'm remembering the name. I think I signed it recently.
Yes, Your Honor.
Okay.
So I don't know if you're going to address that today or wait until.
Let's wait till Ms. Clark plugs in, because when she's filing a motion for bond, she needs to be apprised of the fact that there was a bond and it didn't work out. Mr. Lim, just so you understand, there are a couple active warrants for your client, so he's being taken into custody right now. Ms. Nelson from my office can get you details about that. We were just spending a little time verifying those. So I got you the phone number. I don't know how helpful it's going to be, but he's going into custody now, and you can work with him as to whatever. There were probation warrants, one from Judge McAfee, signed in August, and one from Judge Barwick, also signed in August. So they're local, as in judges here in this building. But it may be something where his case you resolve globally. You know, we resolve the open charges that are with me, and I get those two probation matters pulled from those judges, so we can handle them all here. Okay?
All right, thank you, Judge.
You bet.
May I be excused?
Yes, sir. Thank you.
Thank you.
Hey, Mr. Stevens. I'm all right. I'm Judge McBurney, and I want to give you a couple updates on your case. One, you used to have a lawyer named Ms. Ricks. I don't know if you ever met Ms. Ricks, but she's withdrawn from your case. But we already have another lawyer in place who will be representing you. It's a Ms. Clark. She can't be here today. She's in a different courtroom. Her colleague is standing right next to you. That's Ms. Wood. And she's given you some basic information about Ms. Clark, so you and your family can contact Ms. Clark. She'll have your case going forward. Second thing is, I need to talk to you a little bit about your bond. I signed an order that revoked your bond because you weren't complying with all the conditions of your release. Ms. Clark, your new lawyer, is going to want to challenge that and have a discussion with you present, probably your mother present, certainly a prosecutor and myself, to talk about whether I reinstate the bond or you stay where you are until we can work through the charges you've got. But that'll be one of the first things that Ms. Clark focuses on is what happened to your bond and is there a way to reinstate it? I'm not saying that there is, but she will be your advocate. She'll argue for you to try to get a bond back in place. Okay? Questions about anything I just said? No? Okay. All right. And you're getting Ms. Wood to Mr. Stevens, the contact information from Ms. Clark? Perfect. You're going to wait for Ms. Clark to waive arraignment?
I'll double check. I'm happy to do it for her. When I was speaking with her, there was a little bit of confusion because she didn't realize that he was going to be coming back
Yeah.
since that withdrawal took place.
Oh, so she was on the case and then Ms. Ricks
Yes.
inserted herself and then withdrew herself?
Correct.
Okay,
But I will confirm with her, I can file it if needed, but I'll confirm, but I'll make sure it's done.
okay. Ms. Singleton, anything we need to talk about while Mr. Stevens is right here?
No, Your Honor, I've spoken with him and I'm in contact with his mother.
Okay, thank you for being here as well. So I will see you soon, Mr. Stevens, when Ms. Clark plugs in and wants to talk about bond, okay? Hold on one second before you go. Yes, ma'am. Did you have a question? Okay. Hey, Mr. Stevens, you need to look this way. Yeah.
I'm Andrea, and I was his mother.
Hi, Ms. Meadows.
Hello, good afternoon. Is my son in the same custody until, Miss Clark or Miss Wood? Is he gonna be still detained?
Yeah, he's going to stay where he is because of the situation that arose that prompted the folks who were supervising Mr. Stevens to say it's not a safe situation. Ms. Clark will need to look at that. And then as I was explaining to your son, she will advocate on his behalf to say, here's why there ought to be a bond reinstated. But I'm the one who said, based on the report, we need to freeze things. And then when a lawyer can come in, I thought it was going to be Ms. Ricks. It's not. It'll be Ms. Clark. And she's a very, very able lawyer and will be able to let us know what she thinks is the right thing after she's spoken with you as well. It's not just speaking with your son. Okay. All right. Thank you. All right, and finally on the calendar is Kenneth Dandridge.
Hello, Your Honor.
Hey, Ms. Clark, my recollection is that Mr. Dandridge has a slightly bigger fish to fry than this case. Will this catch this case up to the other case, or is the other case not yet in final plea?
I think that the other piece is already on the trial calendar.
Okay,
If we could bring him out though, I don't know if it makes sense to have a final plea hearing for this case. We can if we need to.
because,
Because the other case is what our focus is on.
right. Well, I mean, we might as well, if he's not interested in working this one out independent of the other, we just get that on the record and then it will move, it will catch up to the murder so that anytime the murder is on a calendar, this will be on the calendar. We wouldn't try this one first. I don't see this going anywhere. So we need to close the loop on the final plea part. Okay. You good with that, Ms. Clark?
Yes, Your Honor.
Okay, and do you have the murder or is that with major case or some other unit?
It's with major case, Your Honor.
Okay, all right. Then let's bring Mr. Dandridge out and then we'll go back to the cases that were on the calendar where we were waiting on the lawyers. Ms. Wood, I just got an email about Ms. Honholt. I thought it had been moved from today anyway, or it got moved to today.
It got moved to today.
Okay, there's an issue at her facility, not involving her, but locking the facility down. Hey, Mr. Dandridge, you can sit right there with Ms. Wood, please.
So she's not a hearing judge?
That's what it looks like. There's a shelter in place going on and the GDC folks are saying it needs to be another day. So I'll copy you. Who's that case with? Ms. Nix and Ms. Nelson, so you can see that.
No objection.
And what was it on for today? Final plea-ish?
Yes.
Okay. Okay, Mr. Dandridge, good afternoon. I'm all right. You have two cases. One is real serious and one is less serious. Your very serious case is already on a trial calendar. This less serious case, we're trying to catch up so that your two cases move together. Your case for today is on for what we call final plea, which would be the last day that you could enter a plea in this case and withdraw it if you didn't like the sentence that you got. I was already chatting with Ms. Wood, who said, why are we doing this? I said, well, we have to do it so that we can have the two cases move together, which is what you should want, that all your business is in one place. Ms. Wood explained that it doesn't make a whole lot of sense for you to plead to this case while the bigger case is still hanging out there. I don't disagree with her, but I got to go through the motions so that we make a record of what's going on. So your case is 24 SC 003520. You're charged with one count of failing to register. You're here in court with your lawyer, Ms. Wood. Ms. Clark is appearing virtually. Ms. Clark, if Mr. Dandridge wanted to resolve the case you have with him today, what would the state's recommendation be?
5 years to serve, Your Honor.
Okay, 5 years. That is pretty understandable. Mr. Dandridge, you understand that if you entered a plea today in this case, the failure to register case, Ms. Clark would recommend 5 years to serve. That doesn't mean that's what I would give you. That means what the state, that's what they would be asking for. Do you understand that? Okay. That doesn't mean that Ms. Wood needs to recommend 5 years to serve. She would advocate for whatever you and she think is a reasonable sentence, but you know what the state is coming in with. Are you interested in pursuing a plea in your failure to register case at this time, or do you want it to move to the trial calendar with your other case? Got it. We will do just that. Ms. Wood, do you have any concerns about discovery in either of the two cases you have with Mr. Dandridge?
No, Your Honor.
All right. Ms. Clark, you feel ready to go on the case you have with Mr. Dandridge?
Yes, Your Honor.
Great. Mr. Dandridge, any questions for me? Wouldn't everyone in jail like a bond? You should talk with Ms. Wood. Your other charge is murder. Murder bonds don't happen all that often. But if you and Ms. Wood have a real good reason to argue for bond in a murder case, I'm happy to hear that. It won't be today because the state needs to have notice. The family of the deceased would have a right to be heard at the bond hearing as to whether they think you should have a bond. I'm required to hear from them if they want to be heard. So talk with Ms. Wood about that. And if she thinks that there is a good faith argument she could make for bond, then I'm happy to hear it and rule on that. Today, we're on just for final plea in just the smaller of your two cases. But if we need to get back together in a couple weeks to talk about bond, we can do just that. All right? Okay. Noted. I appreciate it. Thank you.
Thank you, Judge.
Thank you, Ms. Wood.
Judge McBurney, may I be excused?
Yes, ma'am. I will get an email out today, or you can stay on your case, and they're gone now. But Mr. Chalmers, which is Mr. Partridge's case with Mr. Rao, that's all that's left for Monday. So I'm not trying to be sneaky. I'll let you know once Mr. Chalmers comes out here to say what he's going to do. We're almost done with this calendar, and then we'll find that out. Okay?
Thank you, Your Honor.
You bet. Bye-bye.
Bye-bye.
All right. I thought I saw Ms. Bumpus.
This stepped out with, I think,
With a prosecutor?
yes,
Okay.
she's,
Isn't it your case?
She's mad at me.
Okay, she's mad at you, so she's gonna talk to someone else. Off to a good start. All right, Mr. Daniels, we dealt with. Mr. Buford, did you have any luck reaching, Mr. Tolles? Okay. All right, let's hold on that. Ms. Cabrera, did we hear anything from Ms. Cabrera, Ms. Nelson? We'll see. Ms. Bumpus, good afternoon.
Hi, Judge.
How are you?
I'm okay.
You represent Mr. Key. in one case or all his cases?
All his cases, it should only be two.
Okay, I'm aware of two. There's the one with a bunch of co-defendants and there's one, I believe that's just with Mr. Muse. But you're now on board for both.
Yes, I think that, and I hope I'm not misspeaking, but I think that number two is going to be dismissed if we take out this.
Okay, number two, you say,
I'm a code amendment.
got it. If you plead to one, you think the other is going to be dismissed. Okay, is that something that's happening today?
I would like for it to happen, I need to talk to him.
Okay, great. He's back there. And assuming we've got the right resources, we can do that. Hold on that for 1 minute. I need to get a report from Mr. Partridge about Mr. Chalmers.
Yes, sir, we were, speaking, he's here,
He's coming right out. I didn't know he was coming out. All right.
Come on. I just thought that, so I'm just sharing about it. Judge, I had the opportunity to speak with, we have to state.
Yeah, we got to get someone in here. I saw Mr. Rao, and for a little while, I thought it was Mr. Abate. He had a real streamlined look.
Yeah, he was here, Mr. Rao was here, I've seen both.
You scared him off.
Big bad defense lawyer, I apologize.
It's the lion part.
There you go.
Did you manage to fetch one of the? They disappeared. Okay, well, Ms. Nix is in the room, and so it's okay. I just need to get a sense, because we're letting the jury clerk know, are we bringing in jurors for Chalmers or for Previon? And I'll be there for either one.
Yes, Your Honor. I received a counter offer from that of Mr. Chalmers, related to Mr. Rao. I believe he's still in the same position. I'm not sure if the court would allow it, but we'd like to potentially put it up and see what the court's thoughts are. If the court allowed Mr. Chalmers to potentially withdraw his plea if he does not agree with the court's sentence. If the court would allow that, I think we'd at least be wanting to entertain a non-negotiated feedback, Judge.
Okay. Hello, Mr. Rao. What has changed from yesterday in terms of the parameters? Yesterday, it was 20 to serve from the state and time served from the defense.
Yes, Judge. And yesterday, the time served, that was more of my advantageous hopes with regard to Mr. Chalmers' case. But in speaking with Mr. Chalmers of a realistic resolution, Judge, he's at a 20 serve 5 or something around that area. If the court would accept it, we have extended that to or countered that with Mr. Rao. And he's in his position. I totally understand the case and given the reduction as well that they've offered. So that's pretty much the difference, Judge.
Got it. So state still at 20, and defense would be coming in with 20 serve 5.
Correct.
Got it. So Mr. Chalmers, I understand what you'd like to do, which is, hey, could I have a free bite at the apple? See how it goes with the plea. And that's not how it works now. You are entitled to enter a plea at any time. You could do it today. You could do it on Monday after you look at all those jurors and say, I don't really want to go forward. You could do it halfway through the trial. Now, the state might pull back that 20 years so that once we pick a jury, they may say you can plead, but you're pleading to the indictment, which would be life. But if you want to enter a plea today, it will be what we call a blind plea. Blind meaning only you don't know what I'm going to do. I would need to hear from you and your family or anyone who's going to speak on your behalf. Obviously, your lawyer. I need to hear from Mr. Rao, and I know there are family members who want to be heard from. Would they be available today, or what we would be doing today would just be taking the plea part and confirming that Mr. Chalmers is admitting responsibility and I would find him guilty, but we would defer sentencing to a later date?
The latter.
Okay. That may be even less what you want to do because it wouldn't be closure today. But it sounds like the state really isn't able to go forward with a plea today unless it was a negotiated plea. But if it's going to be a blind plea, a non-negotiated plea, they would want, and they have a right to have family members be heard. before I figure out what I'm going to do. Because in the same way that your story would tug me in the direction of your lawyer's recommendation, I suspect the feelings of loss that that family has would tug me in that direction, which is what I hear at sentencing anyway, if there's a trial. So what you and Mr. Partridge should talk about, and I'll give you some more time to talk because I can turn to this other case. Do you want to go forward today with simply locking in that you've pled guilty, and then we would do sentencing late next week or something, but you would not be able to withdraw your plea if I went with their number, or I might say, you know what, the right number is 15. That's less than what they asked for, but it's 3 times as much as what you asked for. And that may not be something you're interested in locking in because there's not much of an appeal from a plea. You sort of, that's what you get. Whereas if you go to trial and it doesn't go well, there's an appeal. I don't mean it's going to win, but there's at least that chance. So you've got some variables in there. There's also the certainty of a plea. It's not life, and it's not life without parole. But that's a big decision to make. I know you've had a lot of time to think about it, and I'll give you a little more time to talk. But when you come back out, it's going to be up or down, yes plea, no plea, because I need to let the prosecutor know. Obviously, your lawyer needs to. Oh, what do we know from? You didn't send anything about Clayton.
I have a 3 o'clock call with the prosecutor there.
Mhm.
I do also have a motion to continue that I filed over there as well.
Okay.
Just with some, how that went.
Yeah.
And then I do have a conflict letter that is drawn up, prepared, that I'll send over to Ms. Nelson as well.
All right. It's all coming down to the final hours.
Yes.
All right, we'll work through that. But why don't you guys go talk a little bit more. Before you do that, any questions for me, Mr. Chalmers? Okay. All right, you guys talk a little bit more, and let's get Ms. Bumpus back with her client if we can do that. We'll wait to see. Oh, I'll work with the 2 gentlemen. They can get out of here because I can't track their lawyers down. So, Mr. Buford, you should talk with Mr. Tolles talk to me a little bit about you want him to withdraw, or you're fine with him being your lawyer, or you just want him to show up, or because you said almost right away, hey, you got to get me a lawyer. You have a lawyer already.
To my knowledge, I thought coming up here and get a public defender to try something that he's still representing.
Yeah, well, he only entered the case a couple months ago. Why did you think he was not on the case? Oh, okay. He's going to stay on for now. We'll reach out and we'll reset this one time. If he doesn't show up next time, he's out the case. I don't want this to drag out for you or for anyone else.
I'm sorry, I mean to interrupt you. That way I could let the court know if I'm gonna have a public defender, or is he gonna stay? Or if he's not gonna stay,
Oh, it would be great if you would let us know. In fact, what I'm going to do is ask Ms. Wood to give you her contact information so you could call to say it's not working out with Mr. Tolles. Now, I still can't appoint her until he withdraws. His entry of appearance was his kind of swearing, I'm the guy for Mr. Buford. And that's his way of communicating. He paid me and I filed an entry because he shouldn't file an entry if he's not ready to take your case all the way. And he did file an entry. And so that means he's your lawyer until I relieve him of that responsibility. And he has not asked to be relieved yet. So I don't know why he's not here. I suspect he's in court somewhere else, but he's not here. So you need to reach out to him, and we'll do the same, and we'll reset this one time to try to sort this out, okay? All right, anything else? All right. Mr. White, your lawyer is Ms. Cabrera. I don't have any doubts about that, and she's going to stick with you. We can't get through to her, which says to me she's probably in court, so she shouldn't be answering her phone. So we're going to reset your case once. Ms. Cabrera may file a waiver. It's what's happened to most of the other cases here. And all that means is she said not guilty for you and starts the process moving. If she files that, you don't need to come back for this process again. The next time you'd come to court would be because she's filed a motion on your behalf to suppress something, or you're working the case out or something like that. So ideally, you don't need to come back here again unless it's something substantive. And Ms. Cabrera is real good about filing those waivers, but she has to talk to you first. Let me see what's in the system here. I want to make sure, have you ever talked with her? Okay, I want to make sure that when she resurfaces, she can connect with you. So. White. So I've got an address in Riverdale. And I got nothing, no phone numbers or anything. So I'm gonna ask you to write down an email address and a phone number. Best way for Ms. Cabrera to reach you, and we'll make sure that gets to her.
Hey, Bates.
Did you have a detective? We have Detective Bates from South Fulton PD on the call. Is that anyone you needed? Okay. Ms. See if I can read that. Got it. You're good. Thank you.
Is Mr. Buford free to go after I speak to him?
I think so. Give me 1 second. Yes. Yeah. And before you speak with him, you're good to go with Mr. Rakestraw, or you still need to talk with him?
I think we're waiting on an accusation number.
Yes,
Oh.
and I submitted it before I came to court and then got an email from the clerk that there was a mistake on it. So I have my legal assistant submit another one.
Okay. So we're not ready on Rakestraw.
But
No, Josh.
Okay.
If we have a break here in a bit, I can run down and try to speed things up.
Okay. Well, we'll see. You can chat with Mr. Buford, and we'll see what's happening with Key and Chalmers and go from there. Yeah.
Christian Rakestraw is my son, and this is, I'm here with his mother. He said it won't be solved today. We get any kind of information, the second step.
So it may be resolved today. It sounds like there's a paperwork thing they're working on. Good. Yep. I promise. Whatever we do, we'll let you know. And I'll have to tell him too. Okay.
So we can't do the deal, you guys, and follow the calendar, so. You just said we did not talk.
So I didn't know which case you were talking about. I'm happy to take a plea as long as both sides, we can set it real soon. But if the victim needs to be notified, the only case for Mr. Key that is on the calendar today is the one that it sounds like you said the state would be dismissing.
Yeah, this is wow. I'm sorry, Judge. I'm very frustrated.
Okay. Tell me why you're frustrated. You want to plea out a case that's not on a calendar.
Well, originally, I had discussed with the state that would be the plan for today, to get a global resolution.
Okay.
I have emailed everybody, including Madam DA herself, because it's been non-responsive, and my client is literally fighting for his life every day, like everyone else, but he has some special needs. it has been about a month, and it's been non-responsive until I get here today. And now I was told that we could do a global, and this is my first time now hearing what happened.
Okay, well, since we have all the right people here, we could figure out a date certain where what's on the calendar is a plea for that case. So it sounds like it's the 23 SC. That's the one that you've negotiated, that Mr. Key is prepared to enter a plea. Is this the soft shooter one? Okay, got it. That's the one he'd be pleading to, and once that plea goes through, if it does, the state would be dismissing the sawed-off shotgun, whatever this case with the bunch of defendants is. All right. Ms. Nix, I'm familiar with the older case and that there are a number of victims. How much time would your victim witness team need to notify people that it's on for a plea? It's you, Mr. Rao.
I'm working with Ms. Nix on it.
Okay.
Ideally a week, but more than likely it will be 2 weeks to ensure. I think we can do it before the Thanksgiving break. That would be my offer to the court to make sure we can get that done.
So Ms. Bumpus is saying that this is something that has been in the works for a while. Is there a reason why it would take so long to contact everyone, or has it not been in works for a while, or what's the state's rejoinder to what I'm hearing?
So my first conversation with Ms. Bumpus was today, and I think she can agree that was the first time she believes that the concrete offer was made. So I need to now relay that to the victims of this particular case.
Okay.
Whom are very, very, very upset about the incident, and relay this is why we are offering this, and to give them time to draft whatever statement they wish to make.
Okay.
Well, Judge, I would just ask that if that's the case, can the bond be reinstated so that my client can get out of court today? Because I'm literally in tears and I've been upset all day because it's completely unfair how he's being handled.
So Mr. Key had no bond. His lawyer never ended up. Oh no, that's Muse. Either way, while Mr. Key was on bond, he picked up new charges. Why would I be?
That's being dismissed, so they can dismiss that today.
If that's what they choose to do, but I don't know that that's what they're doing. And I don't need you to negotiate in front of me. You all can keep talking. I'm available to do what I can. Mr. Scheib wasn't off the case until yesterday, so I'm a little confused as to how you've been working the case for weeks, unless you were doing that, not having been, I guess. Pardon me?
I filed it was the aggravated assault judge.
Oh, you've plugged in the other case. Got it. Okay, that fits, and that's the one you're trying to work out. Okay, all right. Well, you know how to reach Ms. Nelson, so let's get this on a calendar soon, and the state will need to do its victim outreach, and statements are good. They can appear via Zoom. I don't require folks to be here in person.
And what I'll say to the board is I will start working on this after I leave by eat. And if I can get all of them in pocket for next week, I'll certainly let Ms. Bumpus know and Ms. Nelson know, and then we can schedule something next week.
Okay.
So I'll work with the court and Ms. Bumpus' schedule and make sure that someone's available to take this plea. We can effectuate that next week.
Okay. I appreciate very much the urgency of this. And we do need to move it. Mr. Key's bond was forfeited because of things he did while he was on bond, allegedly. And that's why we're in the situation we're in now. I know you appreciate Ms. Bumpus, and you can help his family understand and his supporters understand that as much as they want to be heard and they're passionate about it, there are people who are passionate about what they went through. I've understood this case all along to be not you got the wrong people or we didn't do it. It's been what we did wasn't something that involved a deadly weapon. So deadly weapon or not, I think you can understand why there are people who were unhappy about what happened, and they ought to be heard as well. And Mr. Rao is committing to jumping on that right away. And it sounds like his first conversation, you may have said what you said to Madam DA, but if that doesn't go to the person who actually needs to do the boots on the ground work, then that hasn't really advanced things for Mr. Key.
That was the last resort after over 4 weeks.
Yeah.
Non-responsive.
Of going to the top. Okay.
That was today because I just got this offer outside, which is very frustrating when it's been on the calendar for weeks and I've been trying, I know my case is, but I understand what's going on and I have done everything I can do to get this moved and no one cares but me.
Okay. Well, Mr. Key is fortunate to have you pushing this forward. What I'll do is get with Ms. Nelson and we will set a date that will be a deadline for the state to have gotten its ducks in a row. And if they haven't, it wouldn't be that they didn't get time to do that. Okay?
And one last thing, Judge, if I can speak with the state and they are inclined, would be inclined to reinstate his bond so that he can go home and come back and take the plea?
You should talk with the state and if you all agree with about something, you can always send an email about that. Okay? Yes, sir.
Listen, I'm accused father and well, you know, he has been sitting down for 4 months with my son. Also, I have these capital records. My son is he's a signed recording artist. He's not a troublemaker. And like I said, 4 months, he has a daughter. He just really needs to get back to his family. And all the respect for boy the gun, it wouldn't cost him their life. My son is fighting for his life every day because of who he is. I was asking him to take this into consideration. This bump has shown me her texts to these people. They are not responding for whatever reason. This is my son's life at stake. You know what I mean? I try to be as respectful as possible. She's done her job. It's my third one. You see, I'm spending good money trying to get my son home. So whatever we need to do gets involved with this today. We can't. My son fight for his life. Boy, the gun's gonna hurt me. It might hurt someone. Call it life. So I just want you to take this in respect. This is his father speaking. This is his grandmother over here. Her blood pressure is high as hell. Out of water. So all due respect, let's just please try to resolve this today. My son is not a game banger. He's not any of those things. He's from capital records. The people, the executives are in the building with you.
Appreciate that they're supporting him. Your son has a way of getting wrapped up in things. It's an odd series of coincidences if he is what you're describing. But today isn't the day for me to assess that one way or the other. You're passionate about this. I am confident that the people who didn't think it was a water gun that was being fired in their direction are passionate about it as well. And I think you can understand why it's appropriate for me to hear from them as well. In fact, I'm required by law to do that.
All due respect, but Ms. Bumpus has been trying to contact these people for over a month. And we're just trying to figure out what's going on.
Okay. Well, the good thing is we're now all in the right place because what the DA's office can't do is put stuff on my calendar, but I can. And you in particular and Ms. Bumpus as a particularly vocal advocate for your son is helping me understand that we ought to prioritize this. So we will do that. It's not going to happen today because the victims can't be here today. They didn't know that through no fault of Ms. Bumpus, they didn't know that today was the day when I'd be hearing about what's going on. I wouldn't have known that either from looking at the calendar. The only thing on my calendar is arraign Mr. Key on another gun case.
That's the problem I have. For some reason, it's not registered, so I'm talking to you because it's like a reason to die. So what I'm saying is just my son needs to get out of here.
Okay.
Okay? It's been long enough. Thanks.
Understood. And if I'm remembering correctly, your son was working through a number of issues. He managed to get shot a bunch of times.
Yeah, that's because he's a celebrity. People, they don't celebrity. They don't. It's unfortunate.
Well, I'm sure there's a story behind that, but I hope he's doing okay in terms of recovering.
I appreciate you, insinuating what my son got shot. He didn't do anything to warrant that. This is his auntie. My son is not like that, sir.
Okay.
With capital record, I have witnesses here.
That's great. The last thing you want to do is start it with me. So you should probably sit down now. You should sit down now and we'll take that up at another time. Yes, ma'am.
I'm surprised on it. I know we can't resolve the case right now. What about the bond? Like maybe an ankle monitor or something like that?
So
I know you revoked it before because he got in trouble while he was on probation or something like that. But that was a month ago. So now it's been another month. So is that even a possibility?
So Ms. Bumpus is gonna talk with the lawyers. If they reach some agreement, they can always get an email to me. I'm not changing anything right now because with Mr. Key where he is, he's not gonna pick up a new case. He's not gonna be around folks with guns. He may be exactly what his dad is saying. I appreciate a dad's perspective. I don't know that that is the most unbiased perspective you get of someone because dads love their sons. The reality is Mr. Key was out on bond. He'd been shot, wants to stay out of trouble, and yet here we are.
So this is the second time.
Well, it's also the second time while he was on bond, he was around guns, and he wasn't supposed to be around guns. So there's a simple way to stay out of jail, and that's stay away from guns. Mr. Key didn't manage to do that. And maybe Capitol Records can take responsibility for that, but they're not the ones who get indicted. So we are where we are, and I am happy to pick this case back up when there's an opportunity for the victims to be heard from as well. Mr. Key is very well heard from, and it's good that everyone was here. There are other people in the mix as well. He and Mr. Muse did what they did, and we need to work through the consequences of that. All right? We're done talking about Mr. Key. I appreciate it. Let's move on to the next case. Yes, ma'am. Yes, appreciate it.
On the unrelated matter, I sent you an email, you get a chance.
Yes, you did. I'll look. That's a long time
We
ago.
started on YouTube the week after.
You think so? Okay.
So,
All right. No, I don't doubt you. I just like 2020. What?
you have a April 21st, 2020.
Yeah.
And I need April 10th, 2020.
Okay. I saw your case is the first one on that calendar.
Yeah, I need it.
I'll see if I can find it. Don't hold your breath on that, but I'll look. All right.
Thank you, Judge.
You bet. Appreciate your time. Ms. Wood, what are we doing with Mr. Rakestraw? Or have you not had a chance to talk to him?
No, we're ready. As soon as we get that number, we're ready to go.
Okay.
Yes.
All right. They're working on that. Okay. How about Mr. Chalmers? Are they still talking?
Yeah.
Okay.
Ready for
Okay.
I don't like it. You see what I'm doing? Like, even though I'm
I know, it's great to have a city folks.
Can it be on the lights?
No. I'll come and get them.
So with Rakestraw, the issue is he'd be pleading to an accusation or he had a second case?
He is pleading to an accusation, and the case that is actually on the calendar, we're gonna introduce to misdemeanor as a little offer.
But the accusation, he has a second charge out there
Yes.
and he's agreed to let it be accused. And so that's what we're trying to get. It's not that what's on the calendar can't be reduced to what you want to reduce it to. Like you're trying to turn an ag assault into a jaywalking. That's not what's going on. He'll plead to the ag assault, it'll be reduced, it sounds like, or whatever happens. But then the other case, just, it was a PI or a CP.
Yes, sir.
Got it. Okay.
Mr. Chalmers is on.
Oh, you're back out.
Yes, sir.
Okay. Can we bring Mr. Chalmers out? Do we need to talk first?
I think he wants to enter a non-negotiated plea.
Okay.
At this point, I just didn't know if we were equipped to do so today with reporters.
Oh, yeah, no, we're good. In fact, we've got, Ms. Rivers is here virtually. We wouldn't go through what's his criminal history or anything because all we're doing is the constitutional rights and locking in the, yes, I'm pleading guilty to voluntary. I'll get it in the record. This is what the state's going to be recommending. It would not be worse than that. Something could change. They could make it better for him. And you can say, this is where we think we're coming in if you want to. You're not obligated to do that because it's a blind plea. But if that's what he wants to do, we should start that now.
Okay.
Great. Is it easier for him to sit? The court reporters are gonna need to hear him. And I want to make that as simple as possible. I don't want to make a big production out of it.
I believe standing might be a little bit better for him.
Okay.
The height of the chairs.
Okay.
And just getting in and out.
So would he stand I think we'd probably stand at the desk then, if that's okay. And then we'll just move the microphone in front for him. Okay.
We just confer with this on really quick.
Okay. Go that way.
I think that's open. It's not my room.
It's open.
There you go. Where you go, Sean? Hoping you'll be Sean, whatever.
What are you waiting? About 5 out on that paperwork. Alright. Right. We don't speak in terms or something today? I'm trying to speak to you like a fan, you know,
I'm sorry.
4 or 5 times.
Wish you all call me.
Yeah, all right. I'm all right. I'm all right, you know it. Taking on you.
All right.
Yep.
Feel that.
Yeah.
Mr. Chalmers, your aunt is here and Mr. Partridge is talking to your aunt. They're going to be in here in a second. I think I had stepped off the bench, but we'll get them back in here now.
We need the indictment, Judge.
We're going to work off a copy.
Okay. Still the same spot? Sure. So we're gonna do the complete part
We won't
today.
be going through the factual.
Correct.
It's gonna go through the facts.
Oh, no, you do need to, because I need to accept the plea. We got to get through accepting the plea, but it can be a generic one. We'll hear from family members and their perspective on another date.
Yes, sir.
All right, Ms. Rivers, are you ready?
After that,
Yes, I am, Judge.
Great.
be able to talk about everything that I need to talk about. Okay. You okay with that? Sure.
All right, let's get on the record so we can figure out what we're doing here. This is 23 SC 187611, State versus Matthew Chalmers. Mr. Chalmers is here in court with his lawyer, Mr. Partridge. We have Mr. Rao here for the state. And Mr. Chalmers, Mr. Partridge shared with me that after much deliberation and the ability to consult with family members, you have decided that you would like to go forward with what we call a blind plea, that you're going to enter a plea. The state, in exchange for this plea, will reduce the murder count to voluntary manslaughter, and they'll be recommending, the state will be a sentence of 20 years to serve. We're actually not going to talk about sentencing today, but I'm going to get the state to commit on the record what they're going to do. They can always make it better for you when we get to sentencing, but they couldn't make it worse, because there are additional counts in this case that could make it 25 years to serve, because there's a gun count, so it could be 20 plus 5. But the state will be locking themselves into the most they would be recommending. We won't do sentencing today. We're going to do that on another day soon, when the family members of the deceased have an opportunity either to be here in person, to appear virtually, or to have prepared a written statement that Mr. Rao or someone could read into the record. So all we'd be doing today is I would accept your guilty plea if I find there's a factual basis and you've just told me, yes, I'm pleading guilty, et cetera. That would mean no trial next week. You wouldn't need to worry about that. It would lock the state in at that 20. And then when we do have sentencing, Mr. Partridge would be able to advocate for the sentence that you and he think is a reasonable sentence. I heard most recently it was 5 years, but I'm not going to ask him to commit to a number today. That can happen when we have the sentencing hearing. Is that what you think we're doing today? Or do you have something different in mind?
Well, I thought y'all were gonna come with a number today, but
No.
No, we can't do the number today because I'm required by law to hear from the victim's family, and they can't be here today. And here may not mean in person, but in the same way that you want family to be around, when we do have the sentencing hearing, if there are other people besides your aunt who you want to have here, they can be here. There'll be time to schedule that. But all I can do today, if you want to go forward with a plea, is lock it in that you pled guilty, no trial, and the state is maximum 20 years. But I won't pick a number today. Pick makes it sound like it's random. I won't sentence you today because we can't have that full discussion where I also hear from the victim's family. So when you leave here today, you will have pled guilty. You don't have to come back on Monday for a trial. When you come back next, you only come back one more time. It'll be for that sentencing discussion. Does that make sense?
yes, it do. I can ask a question.
Yes.
I was trying to see like, if the charge is gonna fold inside the case. Like, all my charges, just like how you said, um, when you try to say it like separate. I want to know if the 20 is like everything.
Yeah, so the state's recommendation is 20 is everything. You have 4 counts. They're gonna reduce murder to voluntary manslaughter. I don't know if they're gonna dismiss the felony murder or if they're gonna argue it's vacated by operation of law. Don't worry about the legal technicalities. The aggravated assault would also go away. It would merge into the voluntary manslaughter. But there's this 4th count, possession of a firearm during the commission of a felony. That doesn't merge with anything. That's there. And it's a 5-year sentence that has to run consecutive to any sentence they give you. Now, the state could choose to dismiss it. And if you haven't had this discussion, Mr. Rao needs to tell us in a minute what he's going to do. If they aren't dismissing it, I can tell you what they're going to do. They're going to say 5 years suspended because they're committing to a 20-year custodial sentence for you. That's what they're going to argue. And so they might say plus 5 years suspended, but that's not probation. That's nothing. That would be you're out. That doesn't bind me. That's what they're doing. But your final sentence will cover everything. It's not that then you have to go to trial on something else. What you're pleading to will resolve all the counts in the case. And so when Mr. Partridge makes a recommendation, let's say he sticks with the 5, he would actually be saying 5 years to serve on the voluntary, and then it would be 5 years suspended on that gun count, unless the state's dismissing it. But let's find out what the state was planning on doing. What were you doing with the gun count?
Yes, Judge. So it'd be 15 years, count 1, amended from murder to voluntary manslaughter. Felony murder would vacate by operation of law. Aggravated assault would merge into count 1, and count 4 would be 5 years to serve consecutive.
There you go. So it is a great question, and it still adds up to 20. It's just with the voluntary, it's 15, and then the plus 5 is on top. 15 plus 5 is 20. All parolable. Those are all parolable numbers. None of them are mandatory minimums, or you must serve a certain amount before you're parole eligible. But that's how they get to the 20.
You understand that?
Mm-hmm. I need you to say out loud, did that answer your question?
Can you like sum it up a little bit more for us?
I got
Sure.
you. So essentially what you have 4 charges, right?
Uh-huh.
You have murder, malice murder, aggravated assault, felony murder, and then the gun charge, right? So 2 of the charges, the aggravated assault, that's gonna roll up into the reduced count of voluntary manslaughter, right? So those 2 will become 1, right? The 3rd count, the felony murder, that's gonna go away. So you don't have that any longer, right?
Correct.
And so you have the gun charge that's left. So we have count 1, the manslaughter, and the gun charge, right? The state is asking between those 2 for 20 years. On count 1, the manslaughter, 15 years. Count 2, the gun, 5. So that's where we get 20 from.
Correct.
You see what I'm saying?
Yes.
On both of those counts, you're eligible for parole for both of those. You understand?
Correct.
So that's what the judge was explaining, that, there's no mandatory minimum. So you don't have, if for instance, you're sentenced to 20 years, you wouldn't serve the full 20 because you would be eligible for parole unless you did something while you were in prison to, negate parole for you.
Correct.
You see what I'm saying?
Understood.
Does that make sense?
Yeah.
Good job.
Thank you, Judge.
So understanding that, 1, that's what the state's recommending, and 2, I'm not giving you the number today. All I'm doing is making sure you understand things like we just did. We're having a conversation, making sure you understand. I'll just be accepting your guilty plea, which is not something you can back out of. Then we will get together again later next week, whenever it makes sense for everyone, to do the sentencing part. That's when the state will say the very same thing. 15 plus 5 equals 20. And then Mr. Partridge will say, that's an interesting number. Here's why you should do this number over here. And you'll have an opportunity to speak too, if you want to. You don't have to, but it's your sentencing. And so I'll certainly hear from you, or if you have family members who want to say something on your behalf, I'll hear from them. And like I told you, I'll hear from the victim's family as well. Okay, does that make sense?
Correct. Yes.
Okay, now that you understand it, is that what you want to do?
Yes, sir.
Okay, then in just a moment, Mr. Rao is going to put you under oath. He's going to swear you in that you're going to tell the truth. He's going to ask you a bunch of questions that Mr. Partridge has already talked to you about your rights. They're not trick questions. If any of the questions you don't understand, do what you just did and say, I don't get that. And then one of us will explain it until you say, now I understand. And then you'll answer yes, no, maybe, whatever your answer is. Okay?
Understood.
Got it. Let's do it.
Gentlemen, please raise your right hand. That's Jody. Do you swear to affirm the statements that you provide the court today will be the truth, the whole truth, and nothing but the truth?
Yes.
You can lower your right hand. Please tell me your true, correct, and legal name.
Matthew Chalmers.
Are you, at this time, under the influence of any alcohol, drugs, or medicine?
I took a Tylenol this morning.
Does that affect your ability to understand the proceedings today?
Oh, no, sir.
And how old are you and how far have you gone at school?
I graduated from high school and I'm 20 years old.
You're 20, you're 20?
Yes.
Are you able to read, write, and understand the English language?
Yes, sir.
You understand that currently you are charged in the indictment for 4 counts. Count 1, murder, which carries a minimum life sentence to a maximum life without the possibility of parole. We are amending that charge from murder to voluntary manslaughter, which carries a minimum 1 year to a maximum 20 years in confinement. Count 2, felony murder, pursuant to this plea will vacate under operation of law, which means you will not be sentenced or convicted as a murderer. Count 3, aggravated assault, that will merge into count 1, voluntary manslaughter, so you will not be under sentence for that particular count either. Count 4, possession of a firearm during the commission of a felony carries a mandatory 5-year sentence to run consecutive to any other count. Do you understand, sir?
Yes, sir.
You understand that the state's recommendation to the court is going to be 20 years to serve on the entire indictment, 15 years on count 1, voluntary manslaughter, and 5 years on possession of a firearm during the commission of a felony to run consecutive count 1. So it'll be a total of 20 years. You understand, sir?
Correct.
You understand that you have the right to plead either guilty or not guilty to these charges, and that if you plead not guilty or remain silent, you may receive a jury trial.
May I repeat that?
Sure. Do you understand that you have the right to plead either guilty or not guilty, and that if you plead not guilty or remain silent, you may receive a jury trial? Meaning if you don't say that you are pleading guilty or if you refuse to answer any other questions, this case is going to trial. Do you understand that?
Yes.
Okay. Have you had enough time to speak with your attorney, Mr. Partridge, about all the facts and circumstances known to you regarding any defenses that you might have should this case go to trial?
I need to reduce
More
that.
time
Say
to talk to me about the case, or have you asked me everything that you needed to know? Do you feel confident that we've talked about everything that you have wanted to talk about?
Yes, I feel why we can't run a concurrent? Why consecutive? Why we can't run a concurrent?
That's how they get the 20.
Oh, all right.
See what I'm saying?
Yeah.
Your question was why aren't they running the numbers concurrently?
Yes.
Yeah, because their recommendation is 20, and they're actually protecting you from the 5 years consecutive after the 20, suspended or otherwise. 15 plus 5 gets them to their 20. So that's why it's consecutive. But they can structure it how they want. Do you feel, Mr. Chalmers, like you had enough time to talk with Mr. Partridge about the strengths of your case, self-defense, and the weaknesses of your case? Maybe your gun, the gun that you're connected to, shot a bullet that was found in the deceased. I mean, you guys have talked about the good and the bad about your case?
Correct.
Okay, you're ready to keep talking? Meaning answering questions?
Oh, yes.
Okay.
Counsel, do you waive formal reading of the indictment and any defects therein?
If there are any defects, we will waive, and we'll waive the reading as well.
You understand that this is a guilty plea which is permanently recorded on your criminal history?
Correct.
You understand that if you are not a U.S. citizen, a guilty plea conviction will affect your immigration status and will result in deportation regardless of any advice by your attorney or anyone else.
Correct.
Are you a U.S. citizen?
Yes.
Okay, that won't apply to
It doesn't
you.
apply to you. That's for immigration purposes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts? Meaning if you get in trouble again, this conviction could potentially be used against you in that prosecution.
Correct.
Do You understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence. Do you understand,
Yes,
sir? Okay. Do you understand that you are not allowed to possess or use a firearm if you are sentenced to probation?
Yes, sir.
You understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial. For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand, sir?
Yes, sir.
You understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, you may be guilty of a felony which carries a sentence of 1 to 10 years in prison.
Yes, sir.
Okay. Mr. Partridge, is your client seeking first offender treatment?
Yeah, we were gonna ask for first offender. He does not have a criminal record at this time, Your Honor, so we would ask the court to consider him as a first offender.
Okay.
Mr. Chalmers, are you asking this court to be treated as a first offender under the provisions of the First Offender Act?
Yes, sir.
Have you pled guilty or nolo contendere to or have ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced to any crime, felony, or misdemeanor under the First Offender Act?
No, sir.
You understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked and you could be adjudicated guilty and resentenced up to the maximum sentence with respect to each charge in the indictment. Do you understand, sir?
Yes, sir.
Do you understand that you waive any and all defenses by entering a plea of guilty today?
Meaning that with entering the plea, we don't have the right to present to the jury any defense at all. We won't be going to trial because the case will stop here.
Correct.
Do you understand?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything for you to enter a guilty plea today?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Say that one more time.
Is it your decision to waive all these rights that I just mentioned and plead guilty because you are in fact guilty?
Are you accepting responsibility or guilt for this case? Is another way to term it.
Yes.
Is anyone making you?
So I'm going to interject here. So this is sort of the key point of the conversation we're having. You at this point can say, I plead not guilty, in which case you're saying, I want a trial. The state needs to prove my guilt. Or you can say, yep, I am admitting to these charges, voluntary manslaughter, the other things fold into it, and the gun count. But it's either or. It's not a, I'm not sure, or something like that. And if you need more time, that's telling me we got to get you in front of the jury on Monday. So the jury can hear the evidence and decide whether the state proved the case. A plea is someone saying, you don't need to prove it. I did it, and I'm ready to move forward. But that's one you need to answer.
Right. Yes.
Okay, so why don't you ask the question again?
Yes, sir. Are you pleading guilty today because you are in fact guilty?
Yes, I plead guilty.
How do you plead to the charges in this indictment?
Can you repeat the charge?
Yes. Count 1, murder, which is now voluntary manslaughter.
Yes.
And count 4, possession of a firearm during the commission of a felony. How do you plead to those charges? Guilty or not guilty?
I plead guilty.
This is guilty plea freely and voluntarily given with the full knowledge of the charges against you.
Say that one more time.
You have a full understanding of the facts in this particular case before pleading guilty. Do you understand?
Yes.
You understand that you have only a limited right to appeal this guilty plea conviction.
Yes.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging this guilty plea?
Yes.
Your Honor, I believe that concludes the plea colloquy.
Okay. Mr. Chalmers, normally what would happen now is I'd ask someone from pretrial services about your criminal history, just because I gather that information. And then I'd turn to Mr. Partridge to say, tell me about Mr. Chalmers. And I will do that. I will hear from him, not today. He's going to tell me a little bit about, oh, no, I need to find a factual basis. So I figure like we hadn't quite finished. Mr. Rao in a moment is going to tell me what he thinks the state would prove if this went to trial. Because I need to find that it's not just you saying you did it, but that what you're admitting to is in fact a crime. Because if you admitted to driving 45 in a 50 zone, that's not speeding. And I shouldn't find you guilty of speeding. But if what he shows me, what Mr. Rao shares with me, is that you were involved in a situation where you shot someone, that's voluntary manslaughter. But I need to hear from him. So listen to that. This won't be the time for Mr. Partridge to say, hey, that's some of the evidence. Let me tell you, there's more, because there's always more. There's this other side to the story. That'll be when we get to sentencing. So I don't want you to think, wait a minute, man, you just let him tell the state side of the story. I'm going to hear it and you're going to hear it. That's just for me to find, do they even have enough evidence for me to take the plea? Because I shouldn't take the plea, even though you're saying, no, Judge, let's do this. If what they say is there was a shooting and the two guys who did the shooting were 7 feet tall. That's not you. I shouldn't take a plea for you in that case. So let's hear what he has to say. All right?
Yes, Your Honor. If this case were to go to trial, the state would expect the evidence to show that on January 14th, 2023, at approximately 11 p.m. at an apartment complex located at 8213 Brookwood Valley Circle Northeast in Atlanta, Georgia, within the jurisdiction of Fulton County, the defendant is alleged to, alongside a co-defendant who remains at large, shoot in the direction of the deceased victim, in this case, Vianta Yancey, 25 times, hitting Mr. Yancey at least 11 times, subsequently killing him. All 11 shots were to the back of Mr. Yancey. 2 of those shots, as ballistics evidence would show, based on the shell casings left at the scene, would have been from the firearm that was seen in the defendant's possession on video camera subsequent to the shooting, after both he and the co-defendant fled the scene and disposed of the firearms in the area adjacent to the apartment building. What's alleged to have happened is that Mr. Yancey, the victim, was in a verbal altercation with his girlfriend at the time through FaceTime, at which point in time, both she as well as her brother, who was present at the scene and also a witness in this case, essentially goaded, for a lack of a better word, the victim into coming to the apartment to have to make that conversation or verbal altercation face-to-face one. Subsequent to Mr. Yancey's arrival to the apartment, it appears that he got into a physical altercation with his girlfriend, at which point in time his girlfriend's brother got into a physical altercation with him, and both defendants in this case were friends of the victim's girlfriend's brother. After that altercation ensued, Mr. Yancey, the victim, retreated to a bedroom, produced a rifle, and started pointing it at other individuals. However, no ballistics evidence indicates that Mr. Yancey ever fired a shot at the scene. At some point in time, as what the autopsy would reveal, Mr. Yancey turned his back towards both defendants and all parties, at which point in time, at least 25 shots were fired in the direction of Mr. Yancey, all hitting his back. Well,
11 hit his back.
11, I'm sorry.
Okay.
11 hit his back, 2 of which ballistics showed matching, one to the defendant's gun, the .4U, which I believe was removed from his heart, indicating that that was one of the shots that ultimately killed the victim. as well as another projectile that matched the co-defendant's gun. The defendant subsequently fled the scene and disposed of the firearms in the adjacent building, but were subsequently identified as perpetrators of the shooting in this particular case.
So were the guns recovered or just the shell casings and bullets were recovered?
Guns were recovered, so they were able to match the shell casings to those particular firearms, and in particular also able to match some of the at least two of the projectiles to those particular guns. The other remaining projectiles, I believe there was 5 other projectiles that were recovered in addition to those 2 projectiles, and those were too damaged to be compared to those firearms.
Okay. So Mr. Chalmers and the co-defendant knew the brother of the girlfriend of the deceased. That's the connection.
That's the connection. They were at the apartment at the time.
They were all there, and you believe the evidence would show that, in a sense, the victim was lured over there by the girlfriend or some friend to continue this fight they were having?
Correct.
Because she was hoping people would jump? I mean, why would she be goading him to come over?
It probably doesn't help the victim's position that it appears that witnesses would say the first thing he did, or one of the first things that he did when entering the apartment, was punching her in the face.
Hence the brother getting involved.
Correct.
Okay.
She essentially told him, if you want to essentially talk like that, you need to come over here and do it.
Okay. And he was not a gentleman when he came in. Things escalated. He gets a big gun, never fires it, and Mr. Chalmers and the co-defendant had guns and they fired a bunch of times. Okay. I understand this resolution more. And I understand the immunity motion. Okay, I appreciate that. Mr. Chalmers, now we are where I said I'd hear about your criminal history, if you have any, and then I would turn to Mr. Partridge to say, what do you want to share? And he would tell me about the case, probably give me a little more detail about what happened in that apartment. Then if you had something you wanted to add, I'd hear from you and we'd hear from family members, et cetera. Today, we're not doing that. I find there's a factual basis for your plea, meaning if this went to trial and the state was able to prove what Mr. Rao said, a reasonable juror could find beyond a reasonable doubt that you intentionally fired at Mr. Yancey and were involved in his killing, which could empower a jury to find you guilty of murder, certainly guilty of manslaughter. And the gun charge is almost pro forma. You had a gun in connection with the manslaughter, and there's that count. So I don't know what a jury would do. This is a complicated case. Mr. Partridge has litigated it well for you. You had that immunity hearing. But all those shots in the back make it kind of hard for a jury to go with self-defense. I know the law that I have to tell them, and one of the things I tell them is that someone who's retreating, that's not an act of self-defense. And one of the best ways to retreat is to turn your back on someone. So again, I wasn't there, and I'm not telling you what happened, but what I'm telling you is I could see a jury finding you guilty, and because of that, I'm finding there's a factual basis. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to plea, but you've decided it's the right way to go forward after you've had a chance to think about it, talk about it with Mr. Partridge and your family. Do you agree that your plea is voluntary?
Yes.
Okay. And a knowing plea means you've understood all the things we've been talking about. Do you have any questions about anything Mr. Rao has said or that I have said?
No.
You feel like you understand where we are so far?
Yes, sir.
Okay, then I'm going to accept your plea. We will reconvene for sentencing. Mr. Rao, you've already explained what the state's recommendation will be. The 15 on voluntary, felony murder is vacated, aggravated assault merges, and then for that gun count, 5 years to serve consecutive for a total of 20 years. But we're not sentencing today. I will talk to you about first offender when we talk about sentencing, because that would be a piece of your sentence that I would include if I do choose to sentence you as a first offender. Do you have a weapons carry license?
No, sir.
Okay. think those are the only questions I needed to ask you and the only things I needed to explain. So I am accepting your plea to count one, which has been reduced from malice murder to voluntary manslaughter. We're not doing the sentencing, but I'm telling you now that at sentencing, count two, which is felony murder, will be vacated, meaning it goes away. Count three, which is aggravated assault, will merge into count one, so it also goes away, which will leave us with two counts, voluntary manslaughter and that possession of a firearm during commission of a crime. Those are the two things that I need to sentence you on. We know what the state's recommending, 15 plus 5. We'll talk when we see each other again about what Mr. Partridge is recommending on your behalf. Anything else you want to talk about?
No, sir.
Okay, well, I adjudicate you guilty as to count one, reduced to voluntary manslaughter, and count 4, possession of a firearm during the commission of a felony. I'm going to work with your lawyer's schedule and Mr. Rao's schedule to figure out a good date sometime soon. When we know if you have family members who want to be heard, they can be here. And when Mr. Yancey's family members, as I said, could either be here in person, they may not want to be here in person for all sorts of good reasons, but they could appear virtually and we still see them. They just talk on that screen. Or like I said, they may just write something out. Okay?
Yes, sir.
All right. Mr. Partridge, anything else on behalf of Mr. Chalmers?
Nothing at this time, Your Honor.
Okay. Anything else, Mr. Rao?
No, Your Honor.
I appreciate it, gentlemen. Thank you.
Thank you, Judge.
So, I don't see Ms. Nix, but we're about, if we don't do Rakestraw now, we're gonna have to do Rakestraw on another day, because I have a meeting at 4. Hey, Ms. Sellers. What's going on? Hey, Ms. Collier. What's going on? Looks like you're coming from a party. Yes, sir. Thank you. Did people go all the way to South Georgia?
No.
Good.
They like to go see.
Okay. What's going on? Did you get him to Judge Ingram?
Mm-hmm.
Excellent. I'm in AD. Ms. Nelson is there. If you don't mind swinging by AD. Okay. AD, that'll be fantastic. You guys are so good.
Okay.
Thank you.
Okay.
Ms. Wood, what is your understanding about the Rakestraw situation?
Miss Nix went to the clerk's office.
To see if she can pry it out of them?
Yes.
Okay, we'll wait a couple more. I know you guys are anxious about this and we'll figure out what's happening one way or the other. You'll leave knowing what's next.
This is his reset. He's supposed to go to court back in October and they didn't do anything. He don't know why.
Okay. Everyone has had some frustrations today.
I'm sorry.
No, you don't need to apologize. And the other folks didn't need to apologize. I understand why folks get frustrated. It is what it is. We'll see when Ms. Nix gets here, what she's got. She doesn't control what the clerk's office does. That's a different piece of machinery. But I can tell you, we can make it happen next week, even though I'll be in trial, if all the paperwork, it's the kind of thing we could do at lunch or whatever. And you're welcome to be here, and certainly Ms. Wood would let you know when it's gonna be. Is it a Ms. Rios thing or a you thing? Rakestraw?
Oh, it's mine.
It's you, okay. But we would be able to do it even if you couldn't make it. So it's not contingent on you being able to make it, okay? All right. Are you supposed to be in 1C?
Is Nick's due to return soon?
Yes.
Okay.
Not today.
Not today?
Judge left early.
Oh, somehow she's getting jurors on Monday. Yeah, that's what it says. Maybe someone's covering for her.
Lando.
That'd be nice.
I don't see it being a crime.
Yeah.
How are y'all? Doing good?
Yeah, Mr. Rao ducked another one.
Here we go.
Yeah.
I think I saved this all week.
Well, I'll be handling something interesting next week, so
Have a good weekend.
see you guys. We're waiting on Ms. Nix. She is in the clerk's office right now trying to say, hey, do you have this thing? So, ma'am, are you waiting on Mr. Partridge? Okay.
Yeah. He actually had two more.
Pardon me?
So he actually had two more, but it wasn't in the system.
Yeah, no, there were two. There's one from McAfee and one from Barwick. I don't know why it wasn't in the system. That's crazy. Probation warrants ought to be uploaded. I mean, that's why we sign them. And they were from August. Yeah, look at the dates that the judges signed them.
Yeah.
Yeah,
It's from 7 and 21.
yeah.
So here's your information.
It's about like week 2.
Don't surprise, he looked out of it. He looked out of it. Yeah, he was pretty placid about it when like, you gotta come with me. There was no like, what?
Thank you, Judge.
Thank you, Mr. Partridge. That was one that I think was wisely navigated.
Indeed, Judge. Thank you.
All right, so Ms. Nelson will coordinate with you and Mr. Rao about a sentencing date, so we can close it out soon.
Sounds good. Thank you, Your Honor.
You bet.
Have a great one.
You too. Have you let Ms. Rios know? I need to send the email out that that's what's going.
Yes, I have. It will be her and Ms. Primovic with you next week.
Excellent. Ms. Primovic was here this morning on a motion for new trial.
I hate I missed it.
It's fun having her testify. Go on, Sarge.
All right, we'll run to the minute, right quick.
Okay, I'm gonna be right here.
That for the record.
Thanks for, yep, the whole YouTube universe know that. That's right. That's PALMER, YouTube world.
Got one more.
Well, we got about a minute for Ms. Nix to make it back here, and then I gotta, we just wouldn't be able to fit the plea in. But we'll see.
You see that seamless arrest that we had?
That was very smooth.
That machine,
It was,
that machine, see?
yeah, it was very smooth. It helps that that guy was pretty high at the time, so he was low resistance. Yeah.
He wouldn't, you didn't want to see that if you tried.
No, it wouldn't have been, I mean, it would have been exciting for,
For the fans.
yeah. Yep.
Rest of them is like they want those. Yeah, you can let it run on and we still. What about you?
Oh, we gonna do it? We gotta be finished.
You can, but I heard him. He said he had a mop, go ahead.
Think where your hat like that.
I like it.
What happened?
It's good. He came straight from the street.
He
Yeah, that guy you arrested might want
plead, yeah, he plead now.
it.
Yes. You should get dropped.
I want to check. Don't you got one more?
The rescheduling will be like in a week or so. If you had to reschedule, it'd be what this.
We would try, well, let me ask this of Ms. Wood. We don't have a prosecutor here, so I don't want to get into any substance at all. Was your understanding that the resolution was going to get Mr. Rakestraw out?
Yes.
Or, I'm not asking you. Was your hope that, or was it negotiated,
It's a
or?
negotiated probation plea. Of course, you know how the jail, sometimes it takes a minute to get the paperwork processed. so-
Sure, but the joint recommendation was a time-served sentence.
Correct.
Okay,
Yes.
and you're not aware of any holds Mr. Rakestraw has?
No, Your Honor.
Okay, so yes, next week is when we were gonna try to do, the only reason why I asked if it was, hey, he's pleading to 3 years to serve, there's less of a rush because he's just earning good time now anyway.
So I have a question. So when you call me and I talk to him later on the day, I can say, son, I'll see you next week.
Yes,
Thank you, I'm going home then.
all right, I'm not going home, but we're gonna wrap up for the day because, we're not gonna have time to do the plea.
I understand. That's fine.
Okay. All right,
Thank you so much. You are excellent judge. I understood you explained everything well. You keep a little slow.
you talk to the Key family about that. Yeah,
This is my only thing, is that, I've been extremely sick and I took a day off. I haven't seen, is you guys come out here just like.
She wanted my eyes on this, say, hey, is that
I
possible?
just kind of want to know.
how about this? Let's bring Mr. Rakestraw to the door so I can let him know next week we're gonna see him, and then we're done. Rakestraw, please.
Just a few more.
Yep, we're gonna do it next week, because I don't have a few more minutes.
Oh, okay.
But I'm gonna bring Mr. Rakestraw to the door to let him know that, I don't know the date next week, but we'll figure out a time during a lunch break during the trial, that we can take the plea.
I'll be here.
Great. And we're back in the home courtroom on Monday.
Yay.
Are you done, Judge?
Yeah, they fixed it. Mr. Rakestraw, how are you? I'm all right. I'm Judge McBurney. And I want to let you know that the state has been working very hard to get an accusation for your other case. And you don't need to worry about the details, but it's a lot of jumping through hoops and bureaucracy, et cetera. They don't have the paperwork yet. And so I'm going to have you brought back next week. And during the lunch break of trial I'm doing next week, I can't tell you which day yet, but Ms. Wood will be here for it. We'll take the plea in your cases. Okay? So we meant to do it today, but for reasons beyond all our control, but really in an effort to accommodate the way you're trying to work this out, the state is accusing your other case. It's almost done, but we're not going to be able to fit it in today. So it will be sometime next week. And as I understand it, you're getting effectively a time-served sentence. So you'll be released that day or the day after, provided no hiccups, and assuming you have no holds. If you got some secret thing going on in Chamblee and there's a hold for you, that just means you get transferred to Chamblee. Okay, any questions?
Okay, thank you very much.
I'll see you next week. All right,
See you next week too. Love you, man. I love y'all.
Baby, thank you, Judge.
you're welcome. All right, Ms. Nix, thanks for your time.
Thank you, Judge.
Sarge,
Right, yeah,
thank you.
I catch you outside, how about that?
Sounds good. Only if you're wearing a hat like that.
Y'all, you too, y'all hear that kid just outside?
All right, good night, everyone.
No, I mean, I will walk very fast. But
Damn it, breathing hard.